So hello and welcome to today's Info2Go webinar. My name is Annie Gaines and I am the Continuing Education Consultant here at the Idaho Commission for Libraries, located in cold and rainy Boise, Idaho. Our webinars and other continuing education opportunities are funded by the Institute of Museum and Library Services. Everyone is muted and we encourage you to use the chat feature to ask questions and discuss with other attendees. As you exit the webinar, you'll be prompted to complete an evaluation. And as always, we appreciate your honest feedback. Today's topic is addressing harassment in the workplace, and our presenters are Benjamin Earwicker from the Idaho Commission on Human Rights and Linda Lee from the Equal Employment Opportunity Commission. Ben and Linda, please take it away.
All right. Well, thank you so much, Annie. I appreciate the invitation, and it's great to see everyone from around the state and around the country. We've got a great representation here from Texas, Missouri, South Carolina, Colorado. I have lots of connections in Loveland and Fort Collins. So welcome. As Annie said, I'm Ben Earwicker. I'm the director of the Idaho Human Rights Commission. And so I'll be bringing the state level perspective. Linda Lee is one of our counterparts in the Equal Employment Opportunity Commission. Through our work-share agreement, we actually collaborate together daily to enforce both state and federal anti-discrimination laws. And so what we're going to talk about today is harassment prevention that falls under both those state and federal laws. So at the state level, we have the Idaho Human Rights Act. In Colorado, in Texas, there are equivalent state laws that sometimes cover the same exact protected categories that we'll get into, sometimes fewer, sometimes more. So on the state side, be sure to check your local statutes on that. Federally, what Linda's going to talk about as we get into this is the overarching federal system and the federal laws that we work under, including the ADA, ADEA, the Age Discrimination in Employment Act, Title VII of the Civil Rights Act. We mentioned earlier, those of you that joined us earlier, the PWFA, the Pregnant Worker Fairness Act, that just came into play in June. So I'm going to move us into the agenda today. What we're going to cover is harassment, broadly speaking. What is and isn't harassment? So what conduct in the context of a library as employees, employers, and working with constituents, what things are annoyances, offensive, and what is harassment, both illegal and legal? Not that harassment is ever okay, but there is harassment that may not tip into the illegal category. We'll talk a little bit about third-party harassment, talking about vendors, constituents, people that come into the library that are not employed by the library. And then finally, we'll talk about best practices and brainstorm about what to do, what not to do. And we have a resource sheet for you to take away from today with links to state and federal agency guidance. The other thing that we'll mention just briefly here is that as we're going through this, we'd love to hear from you in the chat. So if you have questions, rather than waiting until the very end, just throw those in the chat. Both Linda and I are monitoring that and watching for your comments. There will come a point at various stages of today where we're going to ask you questions and ask for your feedback. So if you can just have your chat ready to go, we'd love to have your questions and responses as we go through this. Now, the outcomes today, by the end of today, we want everybody to be able to do a couple of different things. We want to immediately recognize whether you're an employee, supervisor, manager, library director, or just an interested constituent, individual that uses the library. We want you to be able to identify some of the red flags for harassment. What are the things to look out for? At a very low level, what are the precursors to bullying and harassment? What does that look like? If you receive a complaint or if you want to make a complaint, what are the best practices for fairly responding to that, making a complaint? Where do you go? Who do you talk to? What is your responsibility if you observe third-party harassment? Let's say perhaps you're not the target of the harassment, but you overhear something, you see something that's inappropriate. What should you do in that situation? And then finally, what are the best strategies and ways for employees, supervisors, and managers to address and stop harassment from occurring?
Great. Thanks, Ben. So we present to you a blank slate. This is our first opportunity to ask you for feedback. And so if you can indulge me in this exercise, when we say harassment, since Ben and I are from these agencies that are focused on employment, we're going to be talking about workplace harassment. I'd like you to just conjure up what first images or thoughts you have. What do you associate with workplace harassment? Is there something that leaps to mind for you right away? And I'll invite you to just drop a few words into the chat. Like, what do you picture? Who's doing it? Who's engaging in it? Who's targeted by it? What kind of actions? So if you don't mind helping me out by popping some ideas into the chat, and I'll give you some time to type. I will, as you're doing this, just advance the slide, if you will, Ben. When I was looking to illustrate harassment, I wanted to be respectful, not trigger people too much, but I actually captured an image of what I got out of a visual search for the term sexual harassment. Oh, okay, I see. Our chat is populating. Ben, can you give me a couple highlights? What are people saying?
Yeah, so I like what Lisa says, unwanted physical or emotional attention. And we'll talk about different types of attention, what that looks like. Identity-based discrimination, bullying into doing what they don't like because you know you have power over their job. So power differentials. A supervisor targeting disabled employees to make them do things that their accommodations would cover. And if they don't, painting them as a problem employee. Commenting on clothes and appearance, and then repeated requests for dates and socializing.
Oh, and I saw actually above that also somebody mentioned patrons visiting the library. So I thank you all for participating in this exercise. It helps to kind of create sort of a universe of where we're starting from in our understanding of harassment. I think in these days kind of post Me Too, maybe sometimes when we say workplace harassment, some of the first things people gravitate to is discussing sexual harassment. That's pretty understandable. We will cover that and also go beyond that. Somebody mentioned you could be harassed for your disability or other reasons. So I think that's really important. I'll just point out when I did my visual search, you see a lot of pictures of sort of this one-on-one. You often see touching. You see people looming. You see kind of this intimate touch that is maybe unwelcome. I thought what was kind of interesting in some of the image, I was like, oh, look, in the image to the upper right, you see a hand on somebody else's hand on a laptop. And maybe that hand reads as feminine, not to get essentialist about gender or anything, but right, I do think that challenges the notion that harassment is always male against female. So like I was surprised to see that image. It's not a typical image. An image in the middle lower row shows what might read as two male figures, more masculine figures. So I thought that was kind of unusual against the trend. And I'll also point out in the bottom right corner, you actually see what reads as a feminine person with hands on her shoulders. She looks troubled. And there's actually a witness. And I just want to point out very often, if you look at the other pictures, it seems to be a very one-on-one situation. So I was just trying to get our engines revving, having us think about what harassment is or isn't. And do we sometimes rule out things that it is? So next slide.
Yeah, and just before we go on, I would say one of the things that we look for as we're doing our investigations into harassment, and whether that's sexual harassment or other forms, is the statements of the parties themselves. And a lot of times we hear the misconception that, well, it's just a he said, she said, or it's a he said situation, and we have no evidence. Those statements themselves are considered evidence in an investigation. So party statements, even if there's no witness, can still be evidence in an investigation. So keep that in mind. As supervisors, some of you may think, well, there's not much we can do here because we don't have video recording, we don't have a witness. That's okay. You can still use that as evidence. All right.
That's a great point. Thank you.
Yeah. So what we're going to talk about today, we've come up with a visual that we're going to come back to later in the presentation, kind of a continuum or a spectrum of behaviors. And on the left here, you'll see the idea of rude behavior or offensive conduct. Some of you had mentioned microaggressions, right? So verbal comments. These are things that don't rise to a level of illegal conduct, but they're nevertheless problematic and troubling, frustrating. You know, we can think of a lot of adjectives to describe conduct that shouldn't happen in the workplace, but is kind of on the lower end of the scale here under what we would consider to be rude or inappropriate conduct. We start to move to abusive conduct. Now, this is where I would put bullying, low-level harassment that may be pervasive or ongoing. Now, that can tip over into that final bucket, right, of illegal harassment. But there are a lot of things that are in that gray area in the middle. And so we're going to talk about definitions and how do you understand when it shifts into that last bucket of illegal harassment. There are very specific legal norms and expectations that define what is illegal harassment. But we want to look at the whole continuum today, right? What are some conduct and actions that fall into the rude or abusive category that could lead to illegal harassment? So we'll talk through some scenarios here in a minute. Linda, do you want to talk through a couple of these here?
Yeah, sure. And I wanted to give maybe some additional thoughts about distinguish between rude and abusive. And I'm thinking maybe one thing that might be helpful, right? We have to admit for different people might find different things offensive, right? Everybody has their personal norms, and then there's sort of the norms that get established in an environment, right? But maybe one way of distinguishing what's rude from what's abusive is with rude, maybe you could extend that person the benefit of the doubt. You might be like, did they mean that? It could be done out of ignorance, or it could be done because they had a bad day. But with abusive, it's either happening over and over again to the point where maybe you think that's intentional or it's a part of a larger pattern, or it's happening and it's targeted at somebody. So that's one way I separate rude from abusive. Rude might be more like one-off occasional behavior, whereas with abusive, there's a pattern to it. It's either happening so often you think there's intention behind it, or it's aimed at a certain group of people or a certain person. So I hope that's helpful. So
and I think, well, and I think on that point, the intentionality really matters, right? Not that it's okay if someone is unintentional and unaware of their conduct and how it impacts people. That's not okay either, but I would put that in the rude category, right? Somebody who's not thoughtful, who's not considering the impact of their words or actions. And when we tip into abusive, it's intentional, targeted. Someone mentioned microaggressions with having to do with sexuality in particular. We'll talk about misgendering someone. Now, we may talk to a transgender employee or someone that comes in from the public and misgender on accident. And that's easy to correct, and then you move on and it's not a big deal. But when someone does that intentionally to make a point, that shifts it from casual, just an accident into that abusive category.
right. So as we're going through some of the examples, we don't have to go through all of them, but I'll start with a nickname. Sometimes a nickname is used to indicate sort of affection or intimacy or whatever, but like, think about it. Some nicknames go to characteristics about people. So, maybe if somebody calls me OG, or like the old original or a dinosaur, because I am one of the more senior people in my positions, right? I could see that being used affectionately. If I use it for myself, that's kind of one thing. But right, does it contain implications of age discrimination? So again, going back to that notion of, if I say to somebody, please stop calling me dinosaur, right? Then do we tip over from potentially rude, maybe unintentionally rude, to abusive, or heading towards harassment, since it's tied to age, which is a protected characteristic. All right, that's one example. Ben, what would you like to take from this
Yeah,
list?
well, I want to kind of play off of that example, and this comes from a case, and you know, it's long since closed, but I think it illustrates that, the OG's comment. So you might have something that seems very innocuous, or it's fun or silly, and in this case that I'm thinking of, the older nurses that had been there for a while, and by older I mean they had more tenure at this institution, called themselves the OGs. And the technical term comes from the 90s and it means original gangsters. And they used that affectionately because they had the most seniority and the most tenure. Well, one of the nurses misconstrued that, didn't understand what that meant or how it was being used, and she interpreted it to mean old goat. So when they were calling her one of the OGs, she interpreted that and thought that they were calling her the quote unquote old goat. And that was the basis of a complaint of age discrimination. And I think it illustrates how something that starts off as a joke or something that's silly can quickly snowball into that category of what's perceived as harassment. Now, they didn't mean it that way. That wasn't the intent, but that's how it came across. So that's a good illustration of that spectrum and how something that starts as an innocuous comment can shift over.
Right. Does anybody have questions about this? I think maybe we could advance to the next slide, but we're just giving people examples how something could be small or bigger, right? And a lot depends on how people are receiving it, you know. Wait, was this one mine?
Yeah,
Sorry.
yeah.
Okay, so we built this slide thinking about what it is that our investigators look for in a case of harassment. So we're kind of coming at this question from the opposite side as the other slide, right? So when we're looking for harassment, our investigators at EEOC, and I believe also at IHRC, look for these characteristics. And so I'll start with unwelcome. Was the behavior unwelcome, right? You know, we gave the previous example of the unwelcomed nickname. One, when we are thinking of sexual harassment, you know, being asked to go out on a date or for sexual favors, you know, that might be clearly unwelcome. And I'd like to just put an emphasis or nuance on unwelcome. So in some cases, we have had situations where the employee felt pressure in order to keep their job or maintain their job or get their job, and may have participated in the behavior, right? Went on the date or what have you. And just because they participated in it doesn't mean that it was welcome. I just like to point that out. And that might also implicate sort of banter. Like sometimes you're like, oh, ho, you're calling me OG and I want this job. I might go along, but it's really bothering me. So just because somebody's gone along with it doesn't mean it's necessarily something that you should maintain, right? Okay.
Yeah, the second one is interesting, and it's really important to emphasize the or. So there are two types of illegal harassment. One is what's called pervasive or frequent harassment. So these are the comments like the OGs, right, that are perceived as or meant to be demeaning based on a protected class. Comments about disability, about sex, those types of things that are frequent, that may not be really severe or really extreme, but they go on and on and on. The other, and it doesn't have to be both, is severe harassment. There are court cases that deal with the use of the N-word, and courts have said that even one instance of the utterance of the N-word in the workplace against a coworker is considered severe harassment. Now, the context matters and all of that, but that's an example of what can be a severe instance. Sexual assault of a coworker would be severe, both criminal and civil sexual harassment. We'll come back in a minute to Megan, your question about protected class. I'll let Linda talk here about offensive, and then I'll finish out with the protected class piece.
Perfect. All right, so when we're talking about harassment, we're talking about behavior that is offensive to a person, hostile. It's, and when we say that, we use a reasonable person standard, knowing that there are a range of people with different sensitivities out there. We're not talking about the most thick-skinned person who will let any comment or behavior roll off their back. We're not talking about somebody who may be particularly sensitive and react because maybe they've been primed to, but we use a reasonable person standard for determining, has this met the definition under our statutes as illegal harassment. So that's also a factor.
And then based on a protected class, so under both state and federal law, there are a limited number of protected classes. We'll talk about those. State to state, it does differ somewhat. So Washington and Oregon state have additional categories that Idaho and Montana do not have, such as familial status, the presence of minor children. Sexual orientation, gender identity is another one that's explicitly included in the state acts in those states, but not in Idaho and several other states. So a protected class is a requirement for it to be illegal. So if someone harasses me because of my hair color or the way that I dress, maybe they don't like my sweater that I'm wearing and they harass me about that. It's not illegal harassment. It may be offensive, it may be rude, but it's not illegal. So those protected categories are really important here. And Megan, to your question, we get this question a lot. What if I'm being harassed and I'm a person with a disability? Does that count? Can that be illegal? And the answer to that is if the harassment is based on the protected category, that's prohibited, that's illegal. But merely being a part of a protected class, and we'll talk about this as well, we're all members of almost all the protected classes. There has to be a link or a nexus between the two. So harassment on its own is not illegal unless it's connected to one of these protected bases. Now I want to move on. We have a couple more slides, and Linda, I think we wanted to move into the gift of a complaint here pretty quickly. So maybe we could move through these next two a little more quickly.
Sure. I know there's a lot of questions about reasonable person standard.
Mhm.
One of the things about the last slide, I don't want you all to dwell too hard. I just wanted to give you a taste of what it is our investigators will be looking through. My ultimate point in all sorts of presentations is we're not here to train you to become lawyers. And we're not here to say, just because it doesn't meet the standard of legal or illegal, no action should be taken on it. I would say if you're a supervisor or an employer, you still don't want this behavior in your workplace because it doesn't facilitate good interaction or good morale or all kinds of things. So what I would say is I'm just trying to, we're trying to give you a sense of the work that our investigators are tasked with at looking at these standards. And we're trying to give you, again, a sense of like, how do I spot issues? If I think it's harassment, you have the right to file a complaint with either EEOC or IHRC. And we want you to feel more comfortable doing that and coming in and talking with us. And that's it. Some of these things are probably best determined on a case-by-case basis. We just want you to feel comfortable stepping forward and talking to us and thinking about what kind of information might be useful in including in a complaint to us. Does that make sense for people?
Yeah, and I wanted to respond as well to Megan and Ashley here. If you're being harassed for a non-disability or not related to a protected category like sex or gender, race, color, national origin, all of those categories, it's still problematic and should still be reported to a supervisor because any form of harassment should be dealt with. The difference is whether or not you have a legal actionable claim in the courts or with an agency like ours. So there may not be anything we can do about it, but certainly it's something you want to address with supervisors and managers. And And then Ashley, to your question, if you're not being harassed necessarily as a protected class member or because of the protected characteristic, but it creates a hostile work environment, again, still something that needs to be addressed and potentially something like we saw earlier that can morph into a protected category. One example that Lynn and I were talking about was, what if you have a coworker who cooks some very spicy foods and it smells up the office space? And another coworker goes to them and says, you know what? I really don't like your people's spicy food. Now, notice how that was said. Now it's shifted from a complaint about, hey, could you maybe not heat up your food right in the middle of the day because it creates, an obnoxious smell. Now we're using this language of categorizing or grouping, and that person might perceive that as an attack on their national origin or, something to do with that protected characteristic. So you can see how something can very easily shift back and forth between these categories. So any offensive conduct, any harassment should be addressed with management, ideally.
And so then again, this is a little bit analysis from our point of view, because these are the laws that we were given. The laws that we enforce say that you cannot treat somebody differently or harass them because of these protected characteristics. And so we just wanted to lay them out for you. This slide I created to kind of both represent, here are the individuals whose lives are impacted by these laws. But also here are some statistics that give you a sense of the proportion at which these are EEOC statistics. These are the proportion at which charges are filed with our agency. I would say typically for EEOC, it's almost like a tie or very close between disability, race, and gender. And then after that, you see it all come out. But what's the number one charge filed with EEOC is retaliation. And I think, sorry, I should have put Idaho stats on here. This is a slide from my California outreach. Sorry, the second column is the proportion at which we receive them in California, since I'm based out of San Francisco, sorry. But it still gives you a sense of what types of charges we're receiving. I wanted to make a few quick notes about things like, for EEOC, gender includes pregnancy and medical conditions related to childbirth. It also includes, ever since the Supreme Court decision in Bostock, gender identity and sexual orientation. That's what the courts have affirmed. I want to point out, for religion, when we say religion, that protects people who practice mainstream faiths or maybe practice them differently, or non-mainstream, or even people who are agnostic. So it's a broader definition than maybe what you initially think of for religion. Other things that I want to share with you about, again, as Ben mentioned, national origin refers to not just that's the place you come from, but it could be where your family comes from. If there's things about your appearance that reflect that, or your accent, that can be interpreted as national origin discrimination. Ben, any other highlights about this slide?
Yeah, so I would say our numbers in Idaho reflect the federal national numbers as well, with some variation, but disability is generally over half of all complaints. There's a retaliation component to a third of all complaints we receive. So our numbers track for the most part with these numbers that you're seeing on the screen. At the end, where you have equal pay, we also have an Idaho state statute for equal pay, and we assess that under the sex branch as well. So that's that's specifically equal pay between men and women based on sex. The other thing that I would say here is that everyone is represented within almost all of these categories. Now, age is age over 40 and employment. So the under 40 set are not covered until they reach the age of 40. And not everyone has a disability. Now, if we live long enough, hopefully, we may at some point in our lives have a disability, and if that's the case, that's covered. But we also know other individuals with a disability, and there's this other category of associated with a person with a disability. So even if you don't have a disability, your association with a person with a disability is also protected. So the last thing that we wanted to point out is that retaliation, there's the broad definition, the way that people use it in everyday conversation. You know, anything that happens as a result of something else is retaliation. You know, I didn't meet my targets for production this month, and now my boss is retaliating and giving me twice the amount of work. It may technically be retaliation, but it's not illegal retaliation. So retaliation under these statutes means retaliation based on participation in a complaint or a proceeding about illegal harassment or discrimination on one of these protected areas. So in other words, if I make a complaint of sexual harassment and then I'm fired because of it, that's illegal retaliation. If I don't meet my production goals or my work responsibilities and there's a consequence, not illegal retaliation. So that's an important distinction. All right, so the review, Linda, I know you wanted to say a few things here, kind of wrapping up what is harassment.
Yes. This slide we assembled to kind of point out maybe some nuances as we're talking about what is and isn't harassment. Sometimes I look at cases and I wonder, did people not recognize this as a harassment because they had some other image of harassment stuck in their minds? And so while a lot of those photos, obviously it's a photo, it's easier to show physical harassment, we want to point out that harassment could also be verbal comments. It could be visual, it could be graffiti, or it could be posters in the workplace, or things shown on somebody's computer screen. Right? It could be electronic or digital. Now it happens over social media or through text. And sometimes it can happen offsite. When we say workplace harassment, it could happen on a commute, like maybe if somebody's giving somebody a ride home or at a holiday party offsite, on a business trip. Let's see. Oh, we were going to tell stories to share these. So here's my story illustrating maybe a couple of these bullets. We had a case on behalf of some female bank tellers where we alleged sexual harassment, but their harassers were actually a supervisor and a co-bank teller who were actually both female. And what these women said to the bank tellers were, in order to get ahead at this job, you have to dress sexy and you have to play nice with upper management and customers, right? And so in this case, it illustrates that the harasser could be same sex, that the harassment doesn't have to involve lust or sexual attraction. And you may not be the direct target of some of these behaviors. It's not like they were being come onto, but they felt that their job opportunities were being limited from the information and the way they were being treated by these two lead and a colleague. So that's my story. Ben, do you have anything else that illustrates?
Just a few brief stories. One of the ones that we hear a lot in the restaurant industry, but I imagine that this would also apply in the library environment where you have third parties coming in, constituents, patrons coming in, leering and conduct that makes someone feel uncomfortable without physical touch, without necessarily an interaction or verbal comment, but the leering, those types of things. We see that a lot in the restaurant industry, but also in professional services. So that can be unwanted as well. And there's a process for addressing that and identifying that as unwanted conduct. We could talk about mocking employees' religious practices. Another more subtle version of that is an underhanded comment about somebody's religious symbols in their workspace. Somebody says, "Hey, would you mind taking that cross down? I find that kind of offensive. I have some bad experiences with my religious upbringing, and that's offensive." Now suddenly we've got this conflict in the workplace between two individuals with very different religious beliefs and views. If that continues over time, that can turn into mocking or harassment for either one of those employees. All right. I think let's move on now to employer liability. Now, this is more for the supervisors, managers, directors in the room today. The liability to the library or to the umbrella organization or agency happens when a supervisor or manager knew or should have known of the harassment and didn't intervene to stop it from reoccurring. And that's my paraphrase of the legal framework. But knew or should have known is really, really important for you managers and supervisors or directors. So if you know something happened and there's evidence that you knew, there's an obvious responsibility to intervene and stop the harassment from continuing. But that second part is a little more vague. You should have known. Let's say it's a small library, you only have 3 staff members and 2 volunteers, and everybody is involved in the operations, and there's really not a conversation that's heard that everyone isn't aware of. So a supervisor can't hide behind this defense that, oh, I didn't know that that specific conversation or harassing conduct took place, if everyone in the office is generally aware of what happens. So that should have known is a little more of a gray area, but you know, from a legal perspective, take action if you know of something, or if it's reasonably expected that you should know what's happening with your staff. All right.
So if you knew or should have known, what is the supervisor and employer's responsibility? I have a picture of a 3-legged stool, because if you're missing one leg of this stool, then the stool falls down, right? So an employer's responsibility is to take prompt, appropriate, effective action. We don't spell out it must be X number of days or minutes, or, you know, the time is kind of relative. But maybe our suggestion to employers and supervisors is make sure people know this is a priority. Don't radiate, I'll get to it when I get to it, right? This is an important thing. How do you know if the behavior was appropriate and effective? Well, one way you know it wasn't appropriate and effective is if the behavior continues, if the identified conduct or harassment is ongoing, then you know that the behavior was, or sorry, the remedy assumed was not appropriate and effective, because it's still happening. So maybe those are some very simple ideas to put out there. I know sometimes easier to talk about than do, but that's our standard. Next slide. Or
yeah,
Ben, do you want to weigh in on that?
Yeah. Going back to the time frame within which you act, I think that's a really good point. It is relative, and we've seen cases where there was low-level comments that have been made, and think of our color scheme, kind of in the rude category. Somebody who commented on somebody's dress, and it may have been related to sex and gender, but maybe not. And it took them 2 weeks to engage all of the employees and conduct an investigation. And I would say, from my perspective, that's probably a reasonable amount of time to structure interviews, to engage with staff. In other cases where there's alleged sexual assault, we've seen this by third parties or by other employees. I think waiting until the end of the day is too long. When you have an egregious allegation of potentially criminal conduct, that can't wait. And 2 weeks would be an inordinate amount of time and create a lot of liability for the library. So it is relative. The quicker you act, the better. But there are certainly hierarchies of response.
Right. Then I'm looking at the time, and I know we wanted to include a lot of things for everybody, so we're going to do our best, but we might need to speed up a little bit here. If you have questions, ask them, because that's our ultimate goal, is to answer your question. This next little section is really inspired by a training that EEOC has been doing called Respectful Workplaces, which was generated by a task force report that our agency conducted on workplace harassment. And so what I love about this training is, again, the focus is not just on law and compliance, but it also talks about like, well, how do we humans implement the law? We respond to situations not just with logic and rational behavior, but with emotion. And just think about this. If you're experiencing harassment, that's a very emotional thing, right? That's something that we don't acknowledge in the law. And so this is just a reminder, maybe particularly to anybody who has supervisory duties or will become a supervisor. You know, you have responsibility for a lot of things in your job, including people, right? And so maybe this is a reminder that if somebody comes to you with a complaint of harassment, how do you frame that interaction for the best possible outcome? And I will say research has shown that when people perceive a process or a culture to be invested with fairness, they're far more likely to abide with the results of that process, regardless of whether it's the outcome they wanted or not, right? So I'm just emphasizing here maybe a couple of ideas that responding to and reporting harassment can involve emotion, aside from all the factual things or the objective things we're trying to put in there. And so if you're the person who's on the job of receiving that complaint, how can we make the person on the other side understand that we're going to be fair and open? And the metaphor we're going to use here is that of a gift. You know, if you're a supervisor, probably you're not like, oh, my favorite part of the day is to receive a complaint of harassment. It's probably one of the last things you are hoping to do with your day. But if you will, if somebody comes to you, we'd like you to view that as a gift of trust. They're trusting that you will do the right thing, right? And if you can respond with openness and alertness, we think that that process will go better for everyone, for you and for the employee who's reporting something that is very troubling to them. If we could go to the next step. So what we're trying to do here is kind of get you all into the feel of a scenario, right? So here we're picturing for you Hector. Hector says to Hector's supervisor, hey, can I talk to you about something? Note that Hector seems very nervous, is red-eyed. You know Hector to be a solid employee, usually very good at their job, detail-oriented, but recently has been showing up to work late, maybe spending too much time on his phone and out of it. The first thing Hector says to you, and by the way, can we just keep this between us? If you were Hector's supervisor, I invite people in the chat. How would you respond to Hector? Okay, you noticed as a supervisor, performance hasn't been up to normal. Hector wants to pull you aside for a conversation. And the first thing Hector says is, by the way, can we just keep this between us? If you're a supervisor, has this ever happened to you before, that being asked to say something and keep it confidential? I see in the chat, yeah, something's going on. Right? This is exactly on point. I will be as discreet as I can, but certain things I must report, right? The reason we do these slides in this order is, remember what's the standard? If an employer or a supervisor knows or should have known that there's something going on, even now, if Hector doesn't say anything or finish the story, you're being put on notice something's going on, right? So you want to encourage Hector to keep on talking, but you probably also want to let Hector know, but it's my responsibility to resolve this. So I just want to prepare you for this moment that very often accompanies a complaint, which is that employee might ask to let it just stay between the two of you. And the fact that the law places a responsibility upon you and your employer to take action if you're given notice that there may be a problem of harassment.
Yeah, and the thing to remember here is that it's a balancing test, right? So we're protecting the confidentiality of the conversation and private information that should be kept confidential, and the information that needs to be shared so that you can address the concern and remedy and provide remedy to the employee who's bringing the complaint. And so I think you can offer both of those to say, I will protect confidentiality as much as possible. I'm not going to go into a staff meeting and say, hey, Linda just came to me with this complaint. Let's all talk about it, and out that employee in that way. But at the same time, like Whitney pointed out here, if there are things that are mandatory reporting issues of abuse or sexual assault, right, criminal matters, those things have to be reported to authorities. But there are other things that create liability for the library that also have to be addressed in some way. So I think Linda's right on in terms of saying, there are certain things that I can't keep confidential, but I appreciate you coming to me and I'll do that as carefully as I can. Now, what happens if Hector, so he comes to you and says, can we keep this between us? You've had that conversation. And then he reveals that another employee keeps calling him quote unquote retarded and mocks the way that he speaks. Now, does it matter whether or not Hector has ever asked for an accommodation, or or don't know that he has a disability? Maybe it's a speech related disability. Maybe it's a developmental disability. Now, the long and short of it, it doesn't really matter whether he's ever asked for an accommodation or not, or has a registered disability or a diagnosed disability. The point that he comes to you and says, I'm being mocked for this, that should be addressed immediately, whether or not you are aware of a disability. And there's good reason for that, and it's a best practice. So Linda, other thoughts on that, or other
I was
things
going
to
to
add to the
ask you to
scenario?
advance the slide because I think it had some of our scenario
There
on
we
it.
go. Yeah,
Right.
yeah.
So Ben kind of shared with you the first part of our scenario, right? And we wanted you to kind of help us identify, do you see any other red flags and what's going on? So there was an additional part we added to our scenario where, in addition, Hector is telling you the person who's calling me retarded says things like, you'll never be a real man, and repeatedly uses the wrong pronouns for Hector. And so we wanted to ask, do you see anything else, right? Ben has talked about the potential of disability discrimination here, but what do you all make of that second part of the phrasing? You'll never be a real man and is misgendering Hector. Any thoughts? What other red flags might go off for you in this scenario? If you were Hector's supervisor, what else would you be on the alert for? Anybody in chat? Again, in the interest of time, I realized I didn't animate this. I meant to have a red flag come in. I would just say, hey, sometimes harassment can be intersectional, right? Right? There is, yes, thank you, Lisa. Right. This seems like repeated behavior, right? It's happened more than once, right? And also, when the employee says you'll never be a real man, uses wrong pronouns, that could be gender-based or gender identity-based harassment, right? So we see two bases, two protected categories, at least represented here. Just wanted to kind of give us practice recognizing issues, right? So both of those things would be important to talk about and investigate and respond to.
Yeah. And on Hector's side, on the employee side, Hector also has a responsibility to report this to someone. Because if the supervisor, if the director, whoever doesn't know, they can't fix it. They can't take action. And so it's really important for employees, if you have a coworker that's experiencing harassment from a patron, something has to be said in order for the library to be able to do something about it. And so that's a really important point. That again, there's the balance. It needs to be reported and there needs to be action taken to resolve it. Now,
So
Linda,
Ben,
we've got a couple of best practice slides. I think if we can kind of just skip past a couple of these, I mean, these are really important things that we can do as supervisors in response to these complaints. The slides will be available to you after the presentation, so you can look at these in greater detail. I think we want to move on to the spectrum.
third party,
The third
for
and
sure.
the third party. So take a look at these. We've listed a few things of what to say, what not to say, and then some ideas on ways that you could reframe and think through a response. So let's talk a little bit about third-party harassment and what that looks like in the context of the library. You know, the customer is not always right, and the wrong response, even from a government agency or a private library, is not to say, well, you just have to tolerate this. As an employee, as a volunteer, you know, that's how these patrons are, and we just have to put up with it. That's not really true. Now, there's a balance again to be struck at providing a public service to the general public, but we don't have to tolerate abuse or harassing conduct. So this is a policy matter. It's also a law statutory matter. So talk with your directors if you have questions about that. But we want to address third-party harassment by customers, delivery people, vendors, contractors, anyone who's not an employee or a representative of the library. What does that look like and how do you respond to it?
So here we're going to give you a scenario. Merlita is really upset because a library patron who's been coming in during her shift for a few weeks now and noticeably staring her up and down, approached her and asked for her phone number. Merlita said very politely, no, but still doesn't feel good after that experience. So first question to everybody, what are things that might set up red flags for you? What did you notice about this scenario? And I'll invite you to respond through chat. Anything that strikes you about the scenario that should put up your antenna of like, huh, is this harassment? What do you think? Yes, no. What are the things you notice? The continued behavior, right? It's been going on for a few weeks. What's been going on? What do you know? What did Merlita report? What do you think? Is staring something that can be part of harassment, a pattern of harassment? What do you think, people? Okay, yeah, right? Yeah, I mean, it doesn't even have to involve contact. It could be just that like creepy eye thing, right? It could be, yeah, excellent answers,
And
right?
remember, back to our definitions, there's both pervasive or repeated harassment and severe. Now, a lot of things may not fit into either category. If it's a one-time thing, somebody's clearly leering and staring at someone that's working behind the counter, if they go away and it never happens again, it really doesn't fit into either category, right? Now, you can have severe harassment that only has to happen one time to be severe. And one of the examples that we had here is, what if you have a patron who's looking at porn in a community space in the library? That's severe, it's inappropriate. That shouldn't be allowed to continue beyond that one first time once it's discovered. So again, it depends on the situation, what is repeated, what is severe. The best thing to do is to intervene and address things early on before they continue or escalate.
So if you are an employee, what action can you imagine taking? Or do you feel like something else has to happen before you say something? Any thoughts in the chat? If you are Merlita, Or if you're Merlita's friend and giving her advice, can Merlita do anything at this moment? Does Merlita need to wait for something else to happen for this to qualify as harassment? And does it have to be illegal harassment before you say anything? I feel like I'm leading you on. What answer am I looking for? Anyone in chat? Okay, yeah. Talk to your supervisor. Mm-hmm.
And it's a
And then
good
I see somebody else saying,
yeah.
Yes, great responses, right? Sometimes it's easier to fix behaviors if you nip them in the bud early than if you wait for them to become more severe, right? It started with staring, and now this person is asking her for her phone number. We don't really want to wait to see what's next.
And part of the conversation is addressing the nature of these experiences and the subjectivity of it. Now, on the one hand, and Linda mentioned this before, sometimes we see people who are hyper sensitive to any sideways glance or look for various reasons, right? And there are other people who are not sensitive at all, and nothing ruffles their feathers, and they could tolerate just about anything. Not that they should have to do that, but we have a range of subjective experiences and perceptions. And so part of this is the conversation between an employee and a supervisor to check in and say, hey, am I overreacting here? Or is this really as bad as it seems? Or maybe a supervisor saying, you know, we need to take this seriously. You may not think that's a big deal, but it's a big deal. And so there's this conversational piece that's really important to gauge our reactions and the subjectivity. Now, I know,
okay.
Linda, we're kind of coming down to the end of time here. I want to point out, if I can, a couple of these slides. We've got a great story here if you want to look up Aaron Wade and the sliding scale that they developed in the restaurant industry for identifying troubling, problematic, abusive, and harassing conduct. From a yellow to an orange to a red, this mirrors what we talked about earlier. I would recommend looking into this as a code system if you're dealing with patrons where you experience these types of things, or before it happens, to know how would you respond in these situations. Anything else about that, Linda, before I move to the last slide?
You know, yeah, I think this is a great case study we were hoping to get to. I think the idea is there's a lot of pressure put on the most vulnerable person, the person being targeted, to report. And so I just want to say and acknowledge that having allies or bystanders in the workplace is really important for addressing harassment. So even if you're not the target or the supervisor, I think you have an important role to help somebody, you know, and checking impressions with other people. You might check in with your supervisor, but you could also check in with peers and saying, do you see what's going on? I think getting in the habit of talking about something is good because studies show people tend to hold it in and not say anything. And if you learn nothing else from today, is we want to encourage people to talk to each other and find out what's going on and what your options are so you don't feel paralyzed. Okay.
Yeah, absolutely. Well, this is our encouragement to pull up the slides and review them. We have some tips here for workers. We have the right2be.org recommendation for some resources. We have a few tips for employers and supervisors. And then if you go down to the very last slide, we have a QR code and a link that you can click on or scan that will take you to a resource page that has links to agency guidance and resources, reporting information, all of the information that we've talked about today and more that you can access on the shared Google Drive document that we've linked here. Lots of things you can do as employees, supervisors, volunteers, citizens. This list is not exhaustive, but we hope that you can find something useful here and begin to implement that.
Thanks so much for your time. If you have the time, we're obviously giving you a lot of homework because we had so many ideas we wanted to share with you. But maybe in order to make the lessons stick, I would encourage you to think about what's your top takeaway from today's discussion. Is there some behavior you would do differently as a result of this information? And if you really want to make it stick, can you find one person who might really need this information and teach it to them? That's another way to make things stick. You know this as librarians. Third one is sometimes it's hard to talk. So maybe right now think of, is there somebody in your life that you can talk about this to? It doesn't have to be a coworker, it could be. But talking a problem out with somebody else, whether it's your friend or favorite confidant, I think gives us a sense of options and possibility and action. Ben, anything else?
I think that sums it up nicely. Thank you. Thank you everyone for being here, and thank you, Annie, for the invitation.
Thank you both for joining us. Thank you so much for attending, everybody. Remember, as you exit, you'll be given a evaluation, and we appreciate your feedback. I'm going to stop the recording now.